Hello everyone, my name is Manvi and today I'm going to tell you about the right and duties of a shareholder of a company. So let's start. Any individual, business or organization that owns at least one share of a company's stock is referred to as a shareholder, also known as a stockholder. As a proprietor of a company, shareholders enjoy the advantages of its accomplishments through higher stock prices. The company's profitability and image are significantly influenced by its shareholders. Owners of the company are its shareholders. They are the company's principal stakeholders. Now let's see the types of the shareholders. There are two types of shareholders. One, equity shareholder. Second, preference shareholders. Now let's see about the equity shareholders. Equity shareholders. The primary owners of a company are its equity shareholders, who will receive their dividends first when the time comes to distribute them. Next is a preference shareholder. Generally speaking, preference shareholders are not allowed to vote due to their preferred status. They get fixed dividends that are paid out ahead of time to common stockholders and are typically larger than those received by the common stockholders. The number of shareholders in a company depends upon the type of company which they are opening. For a one-person company, one is required. For a private limited company, two persons are needed. For a public limited company, a minimum of 7 persons are required. Now, let's proceed towards the rights of the shareholder. The very first right of shareholder is the appointment of director. A significant influence on the appointment of directors is exercised by shareholders. The appointment requires the shareholders to pass an ordinary resolution. Apart from this, shareholders can also appoint various types of directors that are an additional director who will hold the office until the next general body meeting, an alternate director who will act as an alternate director for a period of 3 months, a nominee director, director appointed in the case of a casual vacancy in the office of any director appointed in a general meeting in a public company. In addition, a shareholder may contest any resolution that the general body meeting passes appointing a director. The second right of shareholder is the legal action against director. A director may also be sued by shareholders under the guidelines set forth in the Companies Act 2013. They are as follows. First, any action taken by the director that negatively impact the company's operation in any way. Second, any action taken that goes against the laws of the Constitution deception. Third, when the company's assets are being transferred at a discount to their market value. Fourth, when the company's finance are diverted. Fifth, any action carried out dishonestly. Third right is the appointment of company's auditor. Generally, shareholders are entitled to choose the company's auditors. The board of directors is responsible for appointing the company's first auditor in accordance with the Companies Act of 2013. Moreover, the audit committee and the director recommended to the shareholders at the annual general meeting. The appointment is typically valid for 5 years and it can be extended by approving a resolution at the yearly meeting of the general body. The fourth right is the voting rights. Additionally, shareholders are entitled to attend the annual general body meeting and cast a vote. Every Indian company that is registered must abide by the rules set forth in the Companies Act 2013. Every Indian company must have an annual general meeting at least once a year. The meeting may be held at the company's headquarters or at any other location designated by the organization. There are several required agenda items that need to be discussed during the meeting. These consist of approving the financial statement, designating or validating the directors, and auditors, among other things. When a resolution is brought by a company of then according to the Companies Act 2013, it can be passed only by the means of voting by the shareholders. Companies Act 2013 recognizes following types of voting. First, voting by the showing of hands. Every member present in the meeting has one vote. So, in this type of voting, shareholders vote by showing of hands. Second is voting by polling. In this type of voting, the chairman of the shareholders demand for a poll. However, in the case of differential rights as to voting, a particular class of equity share may also have been waived voting rights. Next is the voting by electronic means. Every company who has more than 1,000 shareholders has to put up a facility of voting through online means. Every member should be provided with a means of voting of online. Next is the voting by means of postal ballot. Any resolution in the meeting can also be passed by means of a postal ballot. A shareholder also has a right to appoint proxy on his behalf when he is unable to attend the meeting. Though the proxy is not allowed to be included in the quorum of the meeting, in case of voting, it is allowed by following a procedure mentioned in the Companies Act 2013. Next right is the right to call for meetings. Shareholders have the right to call a general meeting. They have a right to direct the directors of a company to call all extraordinary general meeting. They also can approach the company law board for the conduction of general body meeting if it is not done according to the statutory requirements. Next right is the right to inspect registers and book. Since shareholders are a company's primary stakeholders, they have the right to view the books and accounts register and, if they so choose, to ask questions about them. Next, right to get copies of financial status. Stakeholders have the right to get copies of financial statements. It is the duty of the company to send the financial statements of the company to all its shareholders either in a quarterly or annual statement. Next is the winding up of the companies. Before the company is wound up, the company has to inform all the shareholders about the same, and also all the credit have to be given to all the shareholders. Along with these rights, there are some other rights of the shareholders that are: first, when the sale of any material of any company is done, then the shareholder should get the amount which they are entitled to receive. Next is when a company is converted into another company, then it requires prior approval of shareholders. Also, all the appointment has to be done according to the procedures, and also auditors and directors have to be done. Next is a right to approach the court in case of insolvency. Now let's see the duties of shareholders. Additionally, shareholders have obligations and tasks that they must fulfill. In addition to the many rights they possess, they also have many obligations. They are as follows. First, it is important for shareholders to attend general body meetings in order to observe and provide feedback on matters that they believe are not proceeding well. Second, shareholders ought to confer regarding financial issues as well as other subjects. And the last duty is it is important for shareholders to stay in touch with other members of the company in order to keep the track of its progress. Now let's see the conclusion. We can conclude with that the shareholders are crucial to a company's ability to operate. In addition to voting rights and the abilities to influence the company's decision to become insolvent, their rights also include the appointment of the company's auditor, director, and other officials. Every right has an accompanying obligation, which the shareholder must fulfill with diligence. With this, thank you. Hope you liked the video.